Good morning. It's Tuesday, June 2nd, 2020. I'm Benjamin Sanchez, here with Coffee with Law. This week I will be discussing evictions, and in particular, notices to vacate. Today I want to go over a simple rule. Yesterday I told you that the number one mistake that most tenants make in evictions is failing to show up with the lawsuit. Because time and time again, whatever defenses they had go out the window because the judge doesn't hear those defenses. However, prior to an eviction lawsuit starting, the eviction proceeding starts with a notice to vacate. In Texas, all residential evictions must have a notice to vacate prior to the eviction lawsuit starting. Now, there are three different notice periods under the Texas Property Code. There's the normal 3-day notice, there is a 30-day notice, and a 10-day notice. Let me go over each of those really quick. We'll dive into those more as the series progresses. In normal failure to pay rent or some other breach of contract under the lease, or if you hold over past the time the lease is done, requires a 3-day notice to vacate. If a landlord wants to recover attorney's fees and wants to provide notice to the tenant that the landlord will be seeking attorney's fees, then a 10-day notice is required. And finally, if there is a post-foreclosure eviction for a tenant who is in a property, and we're not talking about a landowner or a property owner who's lost the property to eviction. We're talking about a true tenant in a property in which the owner has been foreclosed upon, either in a tax foreclosure suit or some other kind of foreclosure proceeding. Those require 30-day notices to vacate. Now, what exactly does a notice to vacate must have? Well, it must be clear in when you are required to move out. So, for example, if you tell someone that they have 3 days to move out, and let's say it is a Monday, and you tell them that they have 3 days to move out, but then you say you must be out by Wednesday, well, then you've only given them 2 days. And quite frankly, the notice is not clear. It's ambiguous. The law states that all of these notices to vacate periods are a minimum. So it doesn't mean that you must give someone only 3 days to move out, but you have to give them a minimum of 3 days or 10 days or 30 days to move out. As a landlord, you could give the tenant a longer period. As a tenant, you're entitled to at least that much. So if you have a notice to vacate and it is unclear as to when you are to move out, or it is clear that the move out period is shorter than what you're entitled to, then that is a defense. So when the lawsuit is filed, you can raise that up with the judge that the notice to vacate period was either too short under law or it was not clear. And if the judge sides with you, then the lawsuit will be thrown out and the landlord will have to start over again. It doesn't mean that you as a tenant get to stay there forever because the landlord made a mistake on that particular eviction effort. The landlord can keep going over and over with an eviction, keep getting it right, or keep doing it until he or she gets it right. So just be aware that the notice to vacate must be clear as to when you, the tenant, are required to move out. And depending upon the situation, you may have 3 days, which is the normal time, 10 days if they're giving you notice that they're going to seek attorney's fees, or 30 days after a foreclosure. If you have any other questions regarding evictions, please feel free to give my office a call, 713-780-7745. But again, all this week I'm going to be going over evictions, in particular notices to vacate. Because, as I said yesterday, tenants do not have a lot of defenses, but a bad notice to vacate is definitely one of them. I hope you have a great day. Keep your head up and go forward and conquer. Thank you. Have a great day. Bye bye.